In this lecture, we shall discuss the procedure for drafting an application for judgment in default of defense. The procedure for drafting an application for judgment in default of defense. And this has been provided for under Order 13 of the High Court Civil Procedure Rules 2004 CI 47. There are a few points we must note. And if you are listening to this lecture, I would advise that you make sure that you listen to the lecture on applying for judgment in default of appearance before you deal with this particular lecture. There are a few points to note in this kinds of applications. If you look at Order 13, Rule 1, if you are asking for a liquidated claim, you also apply for final judgment. If it's an unliquidated claim, if you look at Order 13, Rule 2, you can apply for interlocutory judgment. If you are claiming indebtedness, Order 13, Rule 3 has particular reliefs you can seek for. If you are coming for possession of immovable property, Order 13, Rule 4 also has reliefs that you can seek for. Then, if you look at the nature of the application, because you are saying that the defendant has not filed a defense, it means that you must bring evidence to show that indeed the defendant has been served with the writ of summons, but he has not filed the defense. So how do you demonstrate that he has been served with the writ of summons? You conduct a what? A search to show that the defendant has been served but has not filed the defense. Many a time you apply for this one, of course, if there is no appearance, then you apply for judgment in default of appearance. But there are times when there will be an appearance but there will be no defense. That's when you apply for judgment in default of defense. So that is the nature of the provision over here. Now, we can look at the drafting of our application. Very simple application. Remember, like I'm saying, you have issued a writ, served the defendant has entered appearance but has not filed a defense. Straight away, just like the judgment in default of appearance. But this one is on notice because the defendant has entered appearance. So if he has entered appearance, you can't go to court without giving the defendant any notice whatsoever of anything that is on the file. So if he has entered appearance, you either apply on notice. So it is the plaintiff applicant and then defendant respondent. Respondent because over here there will be a respondent to the application. They are going on notice. Then you have your motion paper. Please take notice that Babatando Esquire, counsel for and on behalf of the plaintiff applicant, will move this honorable court, praying for final judgment. So let me make it praying for judgment in default of defense against the defendant's respondents for the reliefs. Okay, so this one, let me maintain it. So praying for final judgment in default of defense against the defendant respondents for reliefs A and B endorsed on the writ of summons, and interlocutory judgment for relief C endorsed on the writ of summons. This will let you know that because it's asking for final judgment for reliefs A and B, it should tell you that then these ones will then be liquidated claims. And then the interlocutory judgment is going to be an unliquidated claim, that's the relief C. So right from the onset, you look at this, you can tell why some particular reliefs are being sought. So then we go on. Upon grounds set forth in the accompanying affidavit, and for any further orders as this honorable court may deem fit. Court to be moved on to so and so day or so soon thereafter, as counsel for the plaintiff applicant may be heard. Dated. Then you add that one over there. This is a very important step. Lawyer signs license number Registrar of the High Court Accra, and because it's on notice, you must add this, and for copy of service on the above named defendants. You must add this part over there because it's on notice. So take notes of how the first page of the application looks like. This is how the first page of the application will look like. That will be the motion. So we can then move on to our affidavits. Remember, it's going to be a simple affidavit. You're only going to show that you issued the writ, you served defendant, entered appearance, but has not filed a defense. So let's see. I, James Hughes, of the address over there in the Greater Accra region of the Republic of Ghana, do hereby make oath and say as follows. 1. I'm a deponent herein and the law clerk of the law firm. Sandor and Associates, the law firm mandated by the plaintiff applicant to handle this case. That I have the full authority of the plaintiff applicant to depose to this affidavit of facts which have come to my personal knowledge by reason of the instructions given to the lawyers in my law firm, which I have been fully briefed on. 3, that at the hearing of this application, okay, you can also add over here in this affidavit of facts, so that to the extent also that any of the depositions contained in this affidavit is anchored on law, then same is being made upon advice I have received from my lawyers, which I verily believe same to be true. Okay. 4, that at the hearing of this application, counsel shall seek leave of this honorable court to refer to all processes filed in this suit as if same have been attached to this affidavit as exhibits and sworn to. 5, that sometime on or around April 2021, the plaintiff applicant commenced the present action against the defendant's respondent for the following reliefs endorsed on the writ of summons. Relief A is recovery of the amount of 50,000 cedis representing the value of the goods defendant bought and has refused to pay for despite repeated demands. Relief B is interest on the sum of 50,000 cedis at the prevailing commercial lending rate, calculated from April 1st, 2019 to date of final payment. Then damages for breach of contracts. Then paragraph 6, that after the writ of summons and statement of claim were served on the defendant and respondent entered appearance through his lawyers on the 5th of May 2021. Attached herewith is a copy of the entry of appearance marked as Exhibit A. So you see, we are adding the appearance because if he hadn't entered appearance, then we would have rather applied for judgment in default of appearance. But you are attaching the appearance to show that he has rather entered appearance, but has not filed a defense. That's why you're applying for judgment in default of defense. So paragraph 6 deals with the appearance. We have attached a copy. Paragraph 7, that even though the time for filing a statement of defense has long elapsed, a search conducted in the registry of this court reveals that the defendant has failed to file a statement of defense. Attached herewith is a copy of the search marked as Exhibit B. Remember, under the rules under Order 11, you have within 14 days after the expiration of the time limited for filing appearance to file your defense. So if the time has passed, you say that even at the time for filing a statement of defense has long elapsed, a search conducted in the registry of the court reveals that the defendant has failed to file the statement of defense. Attached herewith is a copy of the search marked at Exhibit B. Then paragraph 8, that I'm advised by counsel and I verily believe same to be true. Now, by the rules of this honorable court, plaintiff applicant is entitled to be granted judgment in default of defense against the defendant herein for the reliefs endorsed on the writ of summons. Of course, because the time has passed, your lawyer has advised you that you can apply for judgment in default of defense. Don't go and say that I can apply, because that is a matter of law and you don't know that law. So you have been advised by your lawyer and you verily believe him to be true. Anytime you are going to say something that is based on legal information, then you add that you've been advised by your lawyer and you verily believe him to be true, that this is what the position is. Because an affidavit is a fact that you can prove. If you can't prove the matter, you don't know CI 47 as a law clerk. You don't go and say that is what it is. You have been advised by your lawyer. Then paragraph 9. Wherefore I pray that this honorable court enters final judgment in default of defense against the defendant respondent for the reliefs A and B endorsed on the writ of summons. What's the relief A and B? Relief A is recovery of the amount over here. This relief A is a liquidated claim. Relief B also a liquidated claim. So we are saying that we are applying for final judgments for the reliefs A and B, and then interlocutory for relief C endorsed on the writ of summons. Wherefore I pray. So one has acquired this day of 2021. Deponent before me, Commissioner of Oaths. Remember, you have to attach a search showing that you've indeed conducted a search. So look at the search. Please conduct a search in the registry of the courts to suppose the defendants to respondents here. So ascertain the following. 1. Whether or not the defendant had been served with the plaintiff's writ of summons. If so, when? Yes. Whether or not the defendant has filed a defense. If so, when? So the answer will be no. So this is what you attach to your affidavits. Then you add your certificate of exhibits and under 20 Rule 14. Copy of appearance and copy of statements of defense. So very simple. This application, the person has been served with the writ, entered appearance, 14 days have passed, no defense. So you can apply for final judgment for the liquidated claim, as you've seen on the face of the motion paper over here. Remember, over here, you must address service on the defendants. You must do this and for copy of service. So this is the face of the motion paper. And also, this is how the affidavit will look like. Remember, the affidavit, you depose to the fact that you served them, entered appearance, but no defense. The moment you mention that there's no defense, what do you do next? It's a matter of law. I've been informed by my lawyer, and I verily believe him to be true, that this is what I must do. You do it, and then you have your way. This will be the end of our lecture on drafting an application for judgment in default of defense. Thank you.